she nodded. Okay. Ms. Vest, will you please call the roll?
Scott Cockcroft,
Here.
Vivian Hickson,
Here.
Ken Roberts, Karen Jones,
Here. Keith
Keith Harvey. Let the record show that Keith Harvey and Ken Roberts are not present, but you do have a quorum, Madam Chair.
Okay, thank you. Have the board members had an opportunity to review today's agenda, and if so, a motion to adopt?
Motion to adopt the agenda.
Second.
We have a motion by Mr. Cockcroft and a second by Ms. Jones to adopt today's agenda. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Have the board members had an opportunity to review the minutes from the June 23rd, 2016 board meeting? And if so, a motion to approve.
Did we have any changes to the,
We did, we made several changes, but they were just typos.
I'll make a motion we adopt.
second?
Okay, we have a motion to approve and a second to approve. All in favor, voice by saying aye.
Aye.
All opposed? And that motion by was Ms. Jones and Mr. Cockcroft. Okay, next on our agenda is the legal report. Ms. Thomas, are you ready to present? Thank you.
The first case is 2016-01791. This is a consumer complaint alleging misconduct by respondent in violation of Tennessee Code annotated 6232-319B9. The complainant contracted with respondent to install a 4-camera system in a rental property. Complainant alleges that respondent charged a higher price than quoted, the installation was unprofessional and incomplete, and the respondent failed to correct the errors. Complainant alleges that respondent did not adhere to appointment times and indicated additional charges would be incurred for subsequent home visits. Respondent denies all allegations set forth by complainant. Respondent states that complainant paid the quoted price for installation. Respondent states that complainant made requests for installation of security systems at additional properties. Respondent states that after the initial installation was complete, complainant indicated that the rental tenants requested the in-home camera be removed and reinstalled in another location. Respondent alleges that upon arriving at the home, complainant made a different request, and as a result, a $70 service fee was charged. Respondent alleges that after the request for the service fee payment, complainant became irate and filed the instant complaint. Respondent provided evidence of the conversations with complainant to corroborate his accounting of the events. My recommendation is to close as the allegations were unsubstantiated.
With counsel.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with her counsel's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2 is 2016-035-231. This complaint opened alleging that respondent is engaging in the business as an alarm systems contractor without a designated qualifying agent in violation of Tennessee Code annotated 6232-304B. The complaint also alleges that respondent is allowing unregistered employees access to records containing sensitive information in violation of Tennessee Code annotated 6232-312A. The complainant is a former designated qualifying agent who indicates the respondent's files are not stored properly. There are several employees with access to files that are not registered, and the company is using a DBA improperly. Respondent states that its files are stored in a locked filing cabinet in a fireproof room. Respondent states that only authorized personnel have access to the files and included a roster of registered employees. Respondent is licensed as a separate alarm systems contractor. Respondent states that the company is in full compliance with state laws and regulations. Finally, respondent states that the complaint arose from a former employee who left the company and sought release from a signed non-compete clause. Respondent states that the company was granted an extension to employ a new designated qualifying agent. My recommendation is closed as the allegations are not substantiated.
What does it mean when it says there's somewhere it said licensed as a separate alarm systems contractor.
The DBA that
Is
the
registered.
complainant alleged
Okay.
is a registered company.
On something like this, would you do an on-site, would an investigator or something go do an on-site visit or anything to verify some of what they're saying, or?
We could ask for an investigation. I think a lot of the allegations made in the complaint were verified via paperwork. If the board would like, I can send it out for an investigation to determine the exact structure of the filing room.
I would question the fireproof room, but the rest of it, I think I would just concur unless they turn them in again, and then you could have a separate investigation. Make a motion to concur with council.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 3 is 2016-021-631. This was an anonymous complaint alleging unlicensed activity by a respondent. The complaint consisted of a quote for services, which included camera recording and monitoring support. Respondent states that the company is a small IT business which sells, installs, repairs, configures, and services computer equipment. Respondent states that the company conducts computer-based monitoring and since the filing of the instant complaint intends to apply for certification as an alarm systems contractor. Respondent states that the company did not perform any work based on the quote. Respondent states that the company has ceased all monitoring and/or recording and the only work performed is low voltage. Respondent states that the company has serviced businesses whose machines are not PCI compliant due to a monitoring device. However, there was not an intention to evade certification. Finally, respondent states that the company has not done any work with fire detection, alarm systems, and/or telephone lines, and the work is performed with IT-related equipment only. My recommendation was to issue a letter of warning regarding Tennessee Code annotated 6232-304A and close.
Make a motion to concur with council.
Why would we not want to do something for the unlicensed activity?
Did the investigation find?
The investigation found that this particular instance, there was no actual work done. It was just a quote for services, and that's why I went with the letter of warning.
Oh, they weren't exempt being the IT company?
Sorry?
They weren't exempt being mainly an
they
IT
were not.
company? Okay.
And so because it was a quote, that's why I started with the letter of warning.
Right.
However,
I'm
if the
sorry.
activity was done, it would have been unlicensed.
While we're here, what's that acronym? What was it? Yeah, what's that mean? I hadn't heard that before.
I believe that goes towards their debit card machines, and if it's being monitored, I think through IT.
That's okay. I just wondered. I hadn't heard it in my jargon.
It does have something to do with credit card machines or credit card processing. I thought that was odd. I guess that's why they're saying that's why they were there, so they weren't there just for,
Yes.
Point of sale device that you can.
right. Well, PCI compliance, I think, is just the compliance in general of all the security.
That stands for Payment Card Industry.
So it's the compliance for all the security-related
Right.
measures, even if it's not electronic processing.
We have a motion by Ms. Jones. Do we have a second?
Second it.
Oh. I don't know. I guess if we take this at face value, and that is the only, I just have a hard time not doing something for unlicensed activity, because had they not been caught, they would have been glad to have sold it and installed. I mean, even sales is a violation, or even a promotion. You have any thoughts, Ken?
Well, she said she was gonna give them a letter, and I was gonna go with that on the first time. Cause if they still do it, they're gonna turn them in again.
Okay, well, I'll second the motion to concur with.
We have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Also, let the minutes reflect that Mr. Roberts has now joined our meeting.
I need to ask for a small break, please, to go off record.
Okay. Back on record. Okay, Miss Ashley, I think we're ready for number 4. Yes, ma'am. Okay.
Case number 4 was 2016-030-871. This complaint opened alleging that respondent is advertising and selling CCTV systems without proper certification. Complainant alleges that respondent's company vehicle indicates that CCTV is offered and installed. Complainant further alleges that respondent fails to register its employees. Respondent states that the current complaint resulted from a bid the complainant lost. Respondent states that his company completed low-voltage wiring and only allowed the customer to purchase equipment from an out-of-state supplier. Respondent states that the equipment is installed by the customer's maintenance crew and is plug-and-play equipment which requires no training and is supported by the customer service staff if necessary. As to the allegation of hiring unlicensed individuals, respondent states that the company has discussed collaboration with an individual in order to expand its business. However, the respondent denies having the individual work in the state of Tennessee. Respondent states that should the individual be hired, an application for his certification will be submitted. My recommendation is to issue a letter of warning regarding Tennessee Code annotated 6232-304E and close.
What type of business is this, Ashley?
It is an alarm business.
So
So
they're just not licensed in CCTV.
they have registered employees?
They do.
Okay.
Say something about, they were talking to another company about I'm gonna use this word, joint venture. You used another word, but is that what that is?
I
They
would
were
believe they were talking about
Yeah.
collaborating. Yeah, that was the phrasing.
with an unlicensed company.
He's not licensed in Tennessee. That's correct.
Statute, but I would have, that's what it looks like to me.
Is there an indication that they are in fact advertising and selling CCTV systems?
I checked their website, and I don't believe that
And-
the website offered it. There was no proof that the company vehicle had CCTV on it as a classification either.
But they're bidding on selling and installing closed-circuit television systems.
Right, and the way he kind of explained it was that he spoke with the customer and then gave him the name of a supplier that was in a different state, from whom they could purchase that equipment.
Sounds like, though, he still did the install, even if the customer purchased equipment out of state, and it's all supported by somebody out of state. That sounds like trying to get through some loopholes to avoid it, but even if they did the install, I mean, with the customer providing all the.
Well, it says that the employee's crew did, not him, but the.
Said that it was plug-and-play equipment, and so the purchaser's
Maintenance.
crew,
The
maintenance crew.
That's what I was struggling for.
The statute that I cited was in fact the joint venture statute as far as the letter of warning in my recommendation.
So we don't have any evidence that they are actually advertising and selling CCTV systems.
We do not.
They admitted basically to it because they're defending their quote, saying that, oh, it's just plug and play, we don't do it.
Know whether or not the system that he installed was something like a school system or some such? You have any information on that at all?
Give me just a second, I'll look through the complaint. There's no indication that it was for a school system, so I can only imagine that it was for a home.
Whether it was a school system or not, I guess is not particularly significant. It's just that the indication here is that he is bidding on selling and installing closed-circuit television systems. Was there any evidence to support that allegation? The states here that the complainant was somebody that presumably lost the bid to the respondent.
That's correct.
Okay, so that would indicate that the respondent then is bidding to sell and install to some degree closed-circuit television systems. Presumably there was some sort of a bid involved.
There was a bid, and so the customer then contacted the respondent company because they had a personal relationship and he knew that he was an expert in this field.
Okay.
He told him that the respondent told the customer that what he was being quoted was exorbitant, and I know you can use my supplier to get this information and get this equipment and you can install it yourself. So lost the bid in the sense that he gave a friend or an acquaintance advice that resulted in the complainant not getting the job.
Let me try and make sure I understand. If the respondent bid on a security system, then that, in my mind, a closed-circuit television system, in my mind, would constitute selling it.
But I don't think he actually.
The respondent
Well,
did not
that's-
bid on
He
that
didn't bid
system.
on
That's
it,
what
so
I'm
it
trying to
says-
make sure I
Yeah,
understand
he didn't
correctly.
bid on it. He
Okay,
told
so
this
somebody
complainant-
else had submitted a proposal. Maybe it should be proposed. Maybe it should be called a proposal rather than a bid, because kind of what you're describing is not an open bid type situation. So the complainant submitted a proposal to sell and install a CCTV system. The purchaser of that system said, no, that's too high. Through some means found information from the respondent company. Friends. Anyway, they got information from the respondent company. The respondent company said, well, that's too high. We will install the wiring, and here's where you can buy the equipment and have your people install it. Would that be a correct understanding?
With the exception of the installation of the wiring, I think that we are saying the same thing. There's no indication that they offered to install any wiring because all they said was it was plug and play. So I'm not sure if they're just plugging it into their personal computers or how they are installing it, but there was no indication that he offered to install wiring.
Okay.
Well, it says respondent states that his company completed low-voltage wiring and only allowed the customer to purchase equipment, so it does sound like they ran the wiring for the CCTV.
All those little facts aside, I would hang up on, if I knew that person that well, why did he go get a quote, inquire for a quote from someone else? If he knows me well enough to where I'm gonna give him my supplier's name and say, here, do it yourself. Why didn't he get a quote from that man first? It's the strange part.
Well, and
Or
some-
get it, buy it
well,
from him first.
Something else too is denies having the individual work in the state of Tennessee how did the complainant know about this person? You know, what did that person do that he got drawn into it? For
Asking
the,
about the complainant?
yeah, the
All
complainant
three of
knew
these
that
parties
he,
knew one another outside of this business relationship.
so the complainant says he's using unregistered people, and then this respondent says, well, he doesn't work in the state of Tennessee. You know, it's just too coincidental that A knows that B is doing this, and then B has an explanation.
Well, I think we're talking about there's a fourth person. There's the complainant, the respondent, the customer, and then the fourth person would be whoever this unlicensed individual was. How did the complainant even know about that individual if they didn't do anything?
That's what I was saying. How did he come into play?
The person that they were discussing collaborating with, again, that goes back to their personal relationship and friendship outside of the alarm business.
They all have been very innocent. I mean, it sounds like somewhat of that explanation, but it also does sound like there was some wiring done. And even if it was on a personal basis, that's okay. But if it was from a company standpoint, even him giving the name and consulting and saying this is what you should buy and this is where you should buy it is a violation of the law.
I would agree with counsel that I feel like that a letter of warning in closing the case is probably appropriate. You indicated that the section quoted here dealt with a joint venture of some sort, which may be appropriate, but I think also just a letter of warning concerning advertising and offering services. I think the letter of warning probably should cite some additional problems that we find with this particular case. Based on kind of what you have indicated, I don't know that we would really have evidence to go further than a letter of warning, to be honest about it. That would be my opinion. With that in mind, I make a motion that we issue a letter of warning and close this case, but I would ask counsel to cite additional areas that the letter of warning should cover in doing that. So I make that a motion.
I second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones, to concur with council's recommendation in this matter to issue a letter of warning, but with additional warnings included in that letter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 5 is 2016-038-951. This complaint opened when the board office received notification that respondent was arrested on April 18th, 2016, to which respondent pled not guilty. Respondent's attorney and respondent's employer provided written notification of respondent's arrest. Additionally, respondent agreed to provide the employer status updates as to the progression of the case. In this case, my recommendation is to issue a letter of instruction to keep the respondent's employer informed as to updates of the case and close.
Do we have any information as to the nature of the offense for which the registered employee, for which the respondent was arrested? Do we have any information on that?
He was charged with aggravated battery.
Okay. Thank you. Madam Chairman, I make a motion we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 6 is 2016-035-051. This complaint opened alleging that respondent failed to include its certification number on its website and advertisements in violation of Tennessee Code annotated 6232-316D. The complaint included a copy of the advertisement as well as printouts from the company website. Respondent states that the failure to include the certification number on its website was an oversight by the web designer and has been corrected. Additionally, respondent states that the company requested to update the website to reflect that the company no longer holds classifications in CCTV. Respondent states that the advertisement was older and was inadvertently distributed to potential customers in error. As of the date of this legal report, respondent's website does not reflect the company's certification number. And I believe, in addition, the board office has indicated that it's still showing a CCTV classification. My recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $250. In the alternative, if respondent provides evidence that the violation has been corrected within 30 days, issue a letter of warning to respondent regarding Tennessee Code annotated 6232 316D and close.
Glad to see the second part of that, the recommendation that if they do correct it, because I would have a really hard time with us issuing a fine for them when we had somebody else that wasn't ever licensed that we just did, so. I would make a motion to concur with council.
In the alternative, correct?
For the, well,
No, he's saying for the letter of warning. Well, but council has two recommendations. Yeah, that's the alternative. So she's provided two alternatives for us to consider.
Right. And the way I approached it was they received the complaint. They told us that they had corrected it. When we looked into it, it had not been corrected. And so that is where I came up with the civil penalty. The alternative to that is once they receive the civil penalty, if they can provide evidence that they have corrected that error, we would reduce the discipline to a letter of warning.
So you're not proposing alternatives for us to suggest or select. You're proposing alternatives in the letter to the response to the responder.
Correct,
Okay.
because typically because the company would get a letter of warning for a first offense, but they have not corrected the error as they said they would, and so that's why I went with the civil penalty.
in essence, we're approving both. If they don't
Correct.
correct it, that would be the $250 civil penalty. If they do, then there'd just be a letter of warning.
Right.
We have the motion by Mr. Cockcroft to concur with our council's recommendation in its entirety. Do we have a second?
I'll second that.
And a second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 7 is 2016-021-651. This complaint opened alleging that respondent failed to notify the board of the transfer and/or termination of the designated qualifying agent within 10 days in violation of Tennessee Code annotated 6232-304C. The board office received a notice of transfer that DQA number 452 was transferring to Alarm Systems Company 1212. Transferring from 1212 to Alarm Systems Contractor 1257 on March 1st, 2016. As of the date of this legal report, respondent has not submitted a termination notice or a transfer notice to the board office. My recommendation is to authorize a formal and send a consent order with the civil penalty in the amount of $250 for violation of Tennessee Code annotated 6232-304C.
Were y'all able to contact the respondent in this? Did they have an explanation or?
They have not responded.
I was stuck on, you probably shouldn't say those numbers. I didn't recognize any of those, maybe company A and company B.
I don't have our.
Yeah, they're not in here, but sometimes I might recognize somebody's license number, but I didn't recognize those. I was kind of stuck on.
That's my mistake. I apologize.
So the office received a transfer. So this is against the company that.
That did not submit the termination notice.
Termination.
So we got a notice from one company, but not from the other.
Got a notice from the DQA.
Okay.
She was transferring. but the company, previous company where they were at, turned them in, said they didn't send it a termination.
No. When he submitted,
QA submitted it, but they never got one from the company.
right, the board office did not get anything from the company showing that they lost their DQA or transferred their DQA.
Oh, I got you.
Make a motion, we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 8 is 2016-022-141. This complaint opened alleging that respondent failed to designate a qualifying agent in each classification of service in violation of Tennessee Code annotated 6232-304. Respondent transferred a designated qualifying agent in the burglar alarm classification effective October 30th, 2015. However, respondent had no designated qualifying agent in the classifications of alarm monitoring or fire alarm, despite offering those services. On May 24th, 2016, respondent obtained a designated qualifying agent in the alarm monitoring classification, and as of June 6, 2016, submitted an application for a designated qualifying agent in the fire alarm classification. My recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $9,750 for violation of Tennessee Code annotated 6232-304B and H. The civil penalty amount represents $750 for each month respondent failed to designate a qualifying agent in the proper classification.
The company have been notified that they weren't in compliance?
Whenever we received a complaint, whenever we,
The
get the
company
complaint
should have
investment.
known that they,
They lost
you know,
their
what
QA.
classifications they had a QA for.
Tell their existing customers and scare them, you know, shake them. Hey, we don't have somebody here. We're trying to do it.
Was there any response from the respondent?
There was, I think there was some work done between the respondent.
Was there a period of time that the company did not have a qualifying agent at all?
I don't believe so. I believe it was a matter of not having a designated qualifying agent in the proper classification.
Did they have qualifying agents that weren't designated for that? I mean, so they didn't have one on staff that just wasn't.
what they did, if I'm not mistaken, and Beth may have to correct me, they moved one DQA over to this spot, brought another one in, moved him over to this spot, then they turned around and moved another one into this spot, and they still didn't have the right classifications in order to be the DQA in the position.
I was just trying to get an understanding, I guess, of if it's a, I know the size of the company doesn't matter, but if it's a really large company and they have a lot of people and if this was a clerical error, if there was, and if they were aware of it, I understand they should be, the qualifying agent should, but
I don't necessarily think it was a clerical error because the board has talked to this company. We've explained to them several times what they need to do, how they need to move to qualifying agents, and we feel like it's their position to know what classification the DQA is to operate their company.
Well, I make a motion that we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 9 is 2016-022-561. This complaint opened alleging that respondent failed to designate a qualifying agent in each classification of service in violation of Tennessee Code annotated 6232-304. Respondent holds alarm licensing in the burglar alarm and alarm monitoring classifications. Respondent transferred a designated qualifying agent in the burglar alarm classification effective October 30th, 2015. However, respondent had no designated qualifying agent in the classification of burglar alarm despite offering those services. On June 6, 2016, the designated qualifying agent in the alarm monitoring classification transferred to a new company. As of the date of this legal report, respondent has not designated a qualifying agent for the classifications of burglar alarm and alarm monitoring. My recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $7,500 for violation of Tennessee Code annotated 6232-304B and H. The civil penalty amount represents $750 for each month respondent failed to designate a qualifying agent in the proper classification.
Does,
They did, excuse
Go
me,
ahead.
did the company report that the DQA for the alarm monitoring transferred, or did y'all find that out because the license were transferred?
They notified the board office of
Okay.
the transfer.
does the company actually provide monitoring services? Madam Chairman, I make a motion we concur with the recommendation of our council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I have two cases I would like for the board to reconsider. The first is 2015-022-0391. This complaint alleged that respondent failed to include a registered employee number 14677 on the company's renewal form in violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K. The board office had not received a termination notice for the aforementioned employee, and the respondent offered no response to the instant complaint. My prior recommendation was to authorize a formal and send a consent order with a civil penalty in the amount of $150. The civil penalty amount represents $50 for a violation of Tennessee Comprehensive Rules and Regulations 0090-01-.069K. Sorry about that. And $100 for failure to respond to the complaint, which is Tennessee Comprehensive Rules and Regulations 0090-01-.06, subpart 13. The board did concur with that decision. As to the update, as of the date of this legal report, respondent has not complied with the outstanding consent order, nor has he offered a response to the board with relation to the allegations. Additionally, the respondent's qualifying agent license expired on March 31st, 2016, and he is outside of his grace period for renewal. Any attempt to pursue employment within the industry would require a new application. My revised recommendation is to close and flag.
Operating?
Company is.
Yes, I'd like to, if I can, clarify that just a little. The DQA did attempt to renew. He expired in March, but he sent his renewal in June. He owed a late fee. He did not pay the late fee, has not paid the late fee. Company and the DQA have been notified of this several times. Has made no attempt to correct this. That means this company does lose their designated qualifying.
You're going to have to speak into the microphone
Excuse me. Did you hear me? I'm sorry.
partially.
All right. So this means this company is losing their designated qualifying agent.
They're still
And he's still been,
operating.
yes, they are still, best that we know, to our knowledge, they are still operating and the individual is still there.
Be proper to send a cease and desist order to them?
Oh, we're gonna send them, yes, ma'am, we did notify them that they lost their qualifying agent. I believe we did that yesterday, right, Beth?
I think the best way to handle it, because they are a licensed company and we can't take away their rights without a formal hearing, we'd have to go through the complaint and hearing process in order to actually stop the company from operating.
Well, why are you recommending that we just close this?
Well, I'm
I don't
recommending.
understand.
I'm recommending close and flag because he's outside of the grace, and anytime he comes back to the board office to renew or submit a new application, this complaint would reopen at that point, and he would have to satisfy that in order to continue in the industry.
I'm afraid I don't understand. It would seem to me that we have a company out there that is providing alarm services of some sort without a DQA, and the recommendation is that we just close this without pursuing a.
I think
The
it's a separate
recommendation
issue.
is against
It's-
the qualifying agent and not the company.
Okay, I see.
We
That was
have
not clear.
established a complaint against the company.
Okay,
Do not
s-
have a designated qualifying
So
agent.
we
That's
do have a
been done.
complaint against the
Yes, sir.
company. So what you're recommending then is that we close the complaint against the qualifying agent?
Correct.
Oh, okay.
And flag it so that if it comes back up, they still have to respond
If
to
he were
it.
to reapply, he would have to satisfy this complaint in order to have that application even considered.
Okay, well, given that understanding, I would make a motion we concur with the recommendation of council to close and flag the complaint against the designated qualifying agent.
Second.
Okay. A motion by Mr. Roberts and a second by Mr. Cockcroft to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye?
All opposed? The motion carries.
And the second case I'm representing to the board is 2014-01771 and 2014-01772. This complaint opened alleging that respondent advertised that they offered access control and alarm system services without being properly licensed as an alarm systems contractor in violation of Tennessee Code Annotated 6232304A. The prior recommendation was to authorize a formal and send a consent order with a civil penalty in the amount of $1,000 for violation of Tennessee Code Annotated 6232304A, which the board did concur with. This update is coming from one of the litigators in the legal department. The update is, according to the owner, the company took down the advertisements and supposedly never performed any of those services. Respondent spoke with the litigating attorney and the executive director, and he understood what he can and cannot do without an alarm systems contractor license. The respondent company is still in business, operating out of Murfreesboro as an automotive lockout company. The revised recommendation is to issue a letter of warning regarding Tennessee Code Annotated 6232316D and close.
The board office did check the website, and as of yesterday, there is no advertisement on the website.
What does an automotive lockout company do?
Unlock cars.
Are they licensed through the locksmith board or?
That's covered under the locksmith program, but anyone can open a car. So they may be doing other things for license.
If anyone gets caught opening a car with burglar tools, they're going to jail. You can't just really open cars. The locksmith law doesn't state that. The
Okay.
municipality states that.
All right. Yes, ma'am, I believe it's against the law to have burglar tools.
What constitutes burglar tools?
I don't exactly know.
Okay. Screwdriver, pair of pliers,
Crowbar.
crowbar.
Anything you use to do something illegal.
Let's move on. I make a motion we concur with the recommendation of council
Second.
and close with a letter of warning.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to concur with our council's revised recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I do want to bring something to the board's attention. It is not on the complaint report. The board office received an application for a registered employee. That registered employee applicant, does have an outstanding complaint that he has not satisfied. The board found him in violation of 6232-320B for engaging or offering to engage in contracting without a certification by use of a falsified license. He falsified a company license and a QA license. The board cited him $5,000. As of today, he still has $3,800 in an outstanding civil penalty, with the last payment being received in June. There was an attempt to reach him by telephone on August 3rd, but there was no response. And I believe the board office is questioning whether or not to offer or approve this application for a registered employee.
So the person's trying to trying to work for someone else in the industry. He was the person was prior self-employed, or
His current status, he's trying to work for another licensed company. The consent order and civil penalty was for his falsification of a company license where he was trying to run his own company.
falsification of documents is kind of goes to poor moral character. But what's you don't have any thoughts or feelings?
You say that y'all tried to make contact with him on August the 3rd. What was that in regards to?
In regards to the outstanding civil penalty, because it was for $5,000, and as of today, he still owes $3,800.
So after the last attempted contact, or there hasn't been any particular contact with this particular individual, you know, that's a real conflict. I'm conflicted in this, in that, you know, here we've got a situation where some individual owes balance of payments on a civil penalty, and you know, if we deny his registration, then he effectively would not be able to work in the industry, which he probably, I say he, I'm using that generically, which the individual probably needs in order to have the money to pay off the civil penalty in the first place. So that's, you know, it's kind of a catch-22. It's not an easy decision.
Actually, Mr. Roberts, he is late on his agreed payment plan, and we are ready to turn him over to collections.
I think it's a thing to do. I think turning the individual over for collection is an appropriate move, but the question here is whether or not we approve his registration.
Because even if it were paid, I would have some concerns over somebody that's willing to falsify documents to try to have an alarm company that doesn't really exist. I'm somewhat conflicted as well, I guess, because I don't think it's just about paying that. I mean, it's not like, okay, he pays $5,000 and he's all good now and ready to go. But that probably would help matters some, but I think we have two issues there.
Seems like to me we ought to deny the registration until such time as the debt is satisfied. Karen,
Did
will
you
you-
make that in a motion? Does that mean that once it is satisfied, you want me to bring it back to the board to review the application for registered employee?
I haven't really made that a motion yet. I'm kind of trying to seek a consensus here.
I missed what kind of, and all the other stuff, what kind of company is it that he was trying to,
Applying to be a registered employee and previously had falsified company credentials and I think you said DQA. He had
Yes, he had,
unlicensed activity. He had a $5,000 civil penalty. He still owes $3,800 and no effort to pay, so they're going to turn him over to collections. But he's
back to the
applying.
document, what did he falsify, how did he falsify that?
company that he was
He
a
falsified the
company,
company license.
that he was a alarm systems.
Was he already a contractor and falsifying it?
He had an application on file and falsified the license to engage in the business as an alarm system contractor.
That's what I was getting at. How did you find out that the papers were falsified? I mean, you wouldn't have known him, the board wouldn't have known him from Adam, he or her.
The number did not correspond to the company name. It was a different company.
That was, I mean, that
That's-
was a whole issue that's already been before the board.
Now
and
he's trying to be a
heard.
registered employee after he did all of that, but he still owes $3,800 from that particular incident.
Yeah, I mean, I was back to the first one. I know y'all talking about money in the second instance. I just wondered how it got through the first time, or how it was told on. Never mind, I'm confused.
I understand you wanting to kind of have some idea of that, but we would have heard that at the time. That would have been a different issue, and when we decided at that point to must have heard enough then to convince us of that. Now, since he was
Excuse me, Scott, could you speak in the microphone?
Sure, I'm sorry about that. Now it's the point of, since that did occur, when we found that prior and he hadn't paid that, but he's wanting to go on and be a registered employee, which he never completed that before, right? The process of being a registered employee.
Yeah. At the time of the prior complaint, it was a not employed status, was his registered employee status. So he wasn't with the company at the prior complaint.
He was previously registered, though.
I think we should deny it, and with it coming back before the board, once the fine is paid, which I think where you were going, Ken.
I second Scott's motion.
I didn't know I made a motion, but okay, I'll make that as a motion.
I need you to repeat it for me and the court
Okay, I'd
reporter.
make a motion that we deny the application until such time as we're denying the application, but at such time as the fine is paid in full, it would come back before the board for review at that point.
Okay,
If there's a new application, we're denying this one. If he reapplies,
it would have to come back before the board for approval.
and it would need to be paid.
And after the civil penalty's paid.
That's why I don't make motions, because I can't
That's
say
all
them.
right.
That is normal procedures. You do have to satisfy any complaints in order for us to.
Okay, Mr. Cockcroft has made a motion that we deny this person's employee registration application and not consider it again until after the civil penalty is taken care of. And it must come back before the board again for consideration as a registered employee.
And I'll second the motion again.
And a second by Mr. Roberts. All in favor, voice by saying aye.
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 All opposed? Motion carries.
Thank you, that's all I
You're
had this
welcome.
morning.
Okay, we're gonna take a 20-minute break. Is everything going good for you?
Okay.
Get there for it. Figured out exactly how to let the air out of it yet.
Our meeting's gonna reconvene. I think the next item on our agenda are the administrative reports. Ms. Best, are you ready for those?
Yes, but I'd like to, since we do have our appearances here, I would like to jump down to the appearances, please.
Okay.
And the first one would be Exhibit G, if you want to turn to it. That would be Michael Campbell.
I was here representing the company. If y'all, the microphone. So that you can speak into the microphone.
Have they signed in?
Yeah, we do need you to sign in.
And that say continuing
that one there?
education? This one on the left says continuing education. He needs to define it on the right. Yeah. Right here as well? Yes, ma'am. All right. We got the first application on June the 30th, and it was denied by material misstatement. So he made a second application on August the 3rd. You do have a written explanation of his charges or the events that happened. So we asked to bring Mr. Campbell in so you could speak with him. So if you would, Mr. Campbell, please give them a few minutes to review. They have not seen this information before.
I was going to suggest that Mr. Campbell might like to make a statement concerning his particular situation and the information that's presented here. Give you an opportunity to make a comment and tell us all about it.
Well, I know that was a book you guys had to read.
Um,
I apologize for that.
Could you introduce yourselves first?
Yes, sir. My name is Michael Campbell. I'm with State Systems, Inc. As you guys have read, I've had a history in the past, a lot of it due to drugs and alcohol. If you read police reports, I had a girlfriend that I was with for 10 or 11 years. As you read, we were pretty passionate. Just was kind of lost. I was out in South Florida. I was making really good money out there. I'm kind of living the life, but I thought I was untouchable. About 7, 8 years ago, I guess I got my felony. At that point, I decided to change my life around. Me and the girl that was in a lot of those reports there were no longer together. I met a girl, moved back to Memphis, Tennessee, to live with her and her son. My father has been with State Systems for like 20 plus years. Was able to get my foot in the door. Started with them pulling wire. Was recently promoted to the office where I was going to be doing estimating and sales support. And then we got the denial letter from the state of Tennessee.
What was your felony conviction for?
Assault with a deadly weapon.
And what were the circumstances around that?
3 years supervised probation.
I know, but what happened? What did you do?
Was in a nightclub, a bunch of buddies, bar fight kind of broke out. Picked up a bottle, guy pushed me, had a bottle in my hand, I fell back, came up and threw it at him, and yeah, lacerations to his face.
Or would you like to speak on his behalf and introduce yourself, please?
My name is Robert McBride. I'm with State Systems, a qualifying agent. Known Michael's father for a long time, growing up in the business, and he's been a good employee, and he's has how many kids, Dennis? How many kids does your dad?
Oh, 5.
5. And so Michael came to us from Dennis and mentioned that he had changed his life around and was looking to make a career out of something, and so we had an opportunity from the ground up and brought him on, and we weren't aware of the past, but he seems to, since before the denial, he was doing a good job and had really impressed his immediate supervisor, and so that's why we brought him in the office, and then we had the denial and kind of took a step back and wanted to see what your thoughts were and go from there.
How long has he worked for you?
Was it a couple months?
Right at 90 days.
90 days. But he's currently working in our technology division, the voice and data cabling.
So are you telling the board, Mr. Campbell, that you no longer drink, do any?
Ma'am, I think, the older I get, the more I'm finding out life's about decisions. And the decisions I've made in the past obviously weren't the right decisions for my life. And after that felony, and I kind of seen where it was kind of like a wake-up call, because everything else was kind of misdemeanors. It was dropped. I was able to keep my current position with my employer. And then when I got this felony, and it was something that I couldn't shake, something that I couldn't get out of, something I couldn't pay to get out of. And right then and there, and as you've seen in my record, I haven't had any trouble since. I had to change my life. And if I didn't, I didn't want to go to jail,
Questions?
What have you been doing in the meantime since then, as far as work, or?
Well, the employer that I was with down in South Florida, of course, I went through like a suspension, probationary period, and eventually I went back to work with him. I started with him back in 2000, I want to say 6 or 7. He was an unauthorized retailer for AT&T, so it was almost like a franchise. We started off with 12 stores when I came into the picture. When I left, we had 52 stores. I was district and regional manager, and also I was assigned a B2B sales team for him. I was a little tired of the retail side of things, the hours, not being able to come home for the holidays because we were blacked out. You know, that's our busy time of the year. And then, of course, there's always a girl. I happened to meet a girl from Memphis in Miami at the time, and we continued a relationship, and we decided for me to come down here, and everything worked out with the job.
So you stayed in Florida after that last conviction for a little while after that?
Yes, sir.
But you weren't with the prior girlfriend, I guess, for some period of time there, or?
Yes, sir. We were together for 10 years. I mean, we went to high school prom and all the way up until 2 years ago.
Recently came back to Memphis in the last.
Yes, sir. Probably 6 months. Felt like it was time for a bigger change in my life. I mean, 32 years old and eventually want a family.
Questions?
I don't have any of these.
Madam Chairman, I find Mr. Campbell's story quite credible. His explanation, the information he's provided, and the support from his qualifying agent. So I would make a motion that we grant his registration.
Second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Cockcroft to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations.
Thanks very much.
And thank you for coming.
And don't forget, you can watch this on television in the future. You know, we wouldn't want to interrupt your employment, but
Thank you.
All right, I believe our next exhibit is going to be H, Mr. Ryan Ezel. Please just sign in, and if you would, your qualifying agent as well, please.
These out here is a copy of.
Just gentleman's back because you've requested his appearance from the last board meeting.
Y'all don't mind, we need an opportunity to review his file before we ask you any questions. Ezel, while the other members are finishing up reading your details, why don't you tell us about yourself?
Well, my name is Ryan Ezel.
To speak into the mic.
Sorry, this thing's a little hung up here.
Simpler solution would be to move your chair over.
There we go. Sorry about that. A little nervous here. My dad sold security for nearly 20 years. And so a few years ago, I figured it would, be something that I would be good at. So eventually I got into the industry and love it. I think it's great. It's the most enjoyable job I've ever had. I was promoted to manager pretty quickly just because. Sorry. Okay. Sorry. I'll get much closer. But outside of work, I have a little girl, and she's 14 months old. So that's pretty much my sole focus. And yeah, that's about it. I work a lot. But other than that, not too much.
Well, you said you were promoted up to manager. What did that include? What were your duties in as a manager?
Hold daily sales meetings, do the recruiting, running daily routes, just managing the office.
When did you start working for this company?
I was just promoted and brought on as manager about a month ago officially. But I worked for them previously, but just recently I was brought back on as manager. I went to another company for a short time and then back here.
So you previously worked for Safe Haven Security. What time period was that?
September of 2014 is when I first started.
And you left when?
12 of 15.
Previously registered with the state as an employee?
I was not.
What were you doing during that time period?
I was also managing the office, but at that time, the manager who was currently in place, he did not inform us, or I guess follow regulations to have all of his employees licensed. So that's kind of why I was previously brought on as manager, because they had to let him go because he wasn't correcting that. So he was actually terminated as of recently.
So you started back to work for this company when?
I believe my first official date was 8/1. It may have been a little bit before that, but I think, yeah, somewhere right around there.
Okay. Do you still have an issue with drinking? That seems to be the source with some of your criminal incidents anyway.
Yes, I do not have an issue with alcohol anymore. I've decided to refrain from alcohol. Just seems to make my life go a lot smoother when it's not in my life.
Sir, will you introduce yourself, please?
Yes, my name is Jim Dodd, the qualifying agent for Safe Haven Security.
Are you in Tennessee or are you in a different state?
Our Kansas City office, ma'am.
So you don't really know Mr. Ezel directly, do you?
Phone conversations and meeting with him. I have his whole history here behind me or in front of me, ma'am. So a little bit about myself. I've been in the alarm industry in various positions, even owning my own businesses for 17 years. To us, integrity is huge, as well as honesty. So when we have managers that aren't doing what they're supposed to, it takes us a period of time to to get rid of him, for lack of better words. So I've been on the phone with him. We've had meetings. We've been talking. I don't want to act like someone's father, but I believe these things start with parents and peers. I have 25-year-old twins that are now business owners that went through this same stuff, alcohol, house parties. So in getting with our management and our business owners, he's assured us that he's turned his life around. Family is most important. He mentioned the daughter. I've asked him if he stopped drinking, the house party stuff and all the other things that were involved in these house parties, and he's assured me that that's in the past. So we're trying to accomplish two things here. We're trying to get a manager with integrity to work and be here, and we have several other people that are going to be employed through Safe Haven here. We haven't started the registration process or anything on them yet because the key is the manager in our beliefs. So at this point, I'm hoping that we can give him a shot, and I'm hoping that I can ride herd on this, make sure that it happens.
What exactly does Safe Haven do?
They're a ADT alarm dealer, so primarily wireless alarm systems, and I'd say probably almost all of our stuff is residential, and that kind of flashes over, into my lifestyle. I'm, as a younger buck, was in still recently people's houses everywhere from they can't pay their bills, and I'm wondering why they're buying an alarm system and there's abuse, to $4.7 million houses for Tiger Woods and so on. So honesty and integrity is key to me. So
Mention your father. He installed or was in the business. Where is he in all this? Is he on his own company? Does he work for this company or?
He was previously a Q&A in Tennessee, but he actually works for an audio-video company, commercial audio-video company.
He's not in alarms anymore.
No, ma'am. I don't think his QA is still current. But if I may, I just want to assure everyone I'm taking this job extremely seriously, and I'm cutting out all of the things that may hold me back, because it is honestly, it's a very good position, and I feel very fortunate to be in the position.
Didn't want to work with your father.
Well, my dad actually I actually did work for my dad for a long time, but that was when he was installing residential audio video. So we would do like home movie theaters and stuff like that. And he also did security. We would pre-wire houses for home security.
He had a QA license?
Yes, ma'am.
With what company?
I'm not 100% sure. His name's Kevin Ezel. It may have been with maybe started with Secure One.
It was an alarm company.
Yes, ma'am.
How long do you work for them?
He worked for Secure One for a very long time, maybe 5 or more years. But he's worked for different security companies in Nashville for, like I said, my entire childhood. Him and Michael Sanford and some other guys that had owned a company together, but that was many years ago. He hasn't been in the security industry as far as what we do in a long time, probably over 10 years.
When did you become a manager for the company here?
It's this past the first of this month. That's when they brought me on officially as a manager.
What were you doing before that?
I worked for a different security company, and then I came back to Safe Haven, and then they promoted me to manager after relieving the other manager of his job.
Okay, but you weren't a registered employee for the other company.
For which other company?
The company you worked with before you came.
Oh, yes,
to
sir, I
Safe Haven.
was. Yes, sir, I was. Mm-hmm. That was Secure Pro. We also filed to have my license to get my license for there as well. But I was only there for 90 days or so.
Let's in on the status of some of that. Do we have the,
When you reviewed his first application, that you had asked to see him?
Okay, so the application that we reviewed before was for a previous company?
Right. And then he reapplied with this company, and you reviewed it at the last meeting and said you still wanted him to come in.
Yes, ma'am, that is correct.
Okay, well, I was just saying that I was looking, this was presented in February, and you've only been with the company since the 1st of August, and that didn't come together for me.
I'm sorry, I should have been more clear. Sorry about that. Yeah, I was at the other company. I wasn't there for long enough to actually come here. Our meeting was after my employment there. But as soon as I came back here, we then applied immediately to come back.
Do you act as the DQA for Tennessee, Mr. Dodd?
Sorry, ma'am.
Do you act as the DQA for Tennessee?
Am I the QA for Yes, I am, ma'am.
Okay.
Right, did I understand you to say that there were, that the previous manager, prior to your coming back to Safe Haven, had some employees, he had not bothered to register the employees?
Yeah, he was from another state. He was from Wisconsin, so I don't know why, but yeah, he didn't. We weren't mandated to be licensed. But I mean, when it was brought to his attention, he slowly started to get to it, but it was never really that urgent. It seemed like it was actually when another alarm company found out about it, and I guess alerted someone that he started taking it seriously. But never serious enough to keep his job, I guess. I don't know.
Well, wouldn't that be the responsibility of the QA or the DQA to ensure that all employees that needed to be registered are registered, and not a manager as a registered employee?
Yes and no, ma'am. It's the QA's responsibility. I can only do so much in pushing 200 people. And when it was a situation where the manager wasn't getting this done, and I was saying we were having turnover because of him, so people were coming and leaving quicker than we could even keep track of. At the end of the day, we just basically said, sir, you have to go. We need to get another manager. We don't want our heads handed to us by the state of Tennessee. We're in about 39 states, very active. We have no problems with any other states. And so we have a licensing coordinator by the name of Jennifer Jesse, and I've been in communication with her a lot. And it's taken us some time because a large company looks at when you terminate people, you know, how the possibility may arise of workers' comp and all the other stuff that comes into play. He said, she said, lawsuits, liabilities. So we were a little bit too careful in how long it took us to try and turn this thing around. So to answer your question, yes, it is the Q&A's responsibility. I feel like I've been chasing ghosts, but I knew I was chasing ghosts, and I put my thumb down, my foot down, and if you hadn't requested me to be here, I would have been here anyhow, and having conversations with him and all that stuff on the house parties and the drinking and so on. It was like, if you excuse my French, dude, we're not going to stand still for any of this stuff. We've had problems with this previous manager, and I'm not happy about it. So
have you gotten all of your other employees registered since you've had the turnover?
we have a list. I have a list actually in my pocket on my phone from Jennifer Jesse as to who these people are. They're not out working. Everyone is on standstill until we feel we have a manager that can then make sure that they're doing what they do, that can make sure that they said that they are who they are. Not, I've been selling for 50 years and I'm good. I don't need training. So we're waiting to get a manager. But yes, we have, I believe, 5. I'd have to look, but 5 people that are hinging on us getting a manager for this area first.
So how many employees do you have working here in Tennessee?
At this time, we don't have any working right now because we're on a standstill with the licensing portion of this.
Are all of the people you indicated 5 employees, are they basically sales representatives or installers or?
They're going to be sales representatives, and once we get that part of the licensing handled, then we'll be looking at the installation side of it.
Okay, so how long have you had an operation here in Tennessee?
Well, they started to do this at some period back, clear back to when he was here in 9 of 14 is when we started getting me licensed. Actually, I was previous to that, but getting me licensed to start working on this office. So in some states it takes us a year and a half, and part of the problem is these people come and go. And so we have to like pull the plug and say, we don't have the integrity that we need there. And
Personnel problems seem to be an ongoing problem with, I
Yes,
guess,
sir.
everybody coming. So you've been operating here in Tennessee since the fall of 2014. Did I understand it correctly?
the company, the office, our home office in Kansas has been trying to open the office. So other things have come into play, like where do we locate the office, rents, things like that. So we've been, my best answer is we've been working on this, trying to get this started, but the licensing process hasn't been coming into play because these ghosts just keep coming and going.
Since 20, excuse me, did I understand you say September of 2014?
Correct.
Okay. So
and we've had licensed people. The company has had licensed people here in the past, and I don't have that list of names in front of me, but
sure. The previous manager, was he with the company very long? And I'm talking about prior to Mr. Ezell.
I think he was there for around a year, possibly.
Okay, about a year.
Uh-huh.
Do you know how many employees you had then?
He had around probably 6 on average. And the people that were out working and that are out and that have ever worked, they have all been licensed. So we have, we have had licensed representatives in the office.
So a total of 6 employees, would that be my understanding?
At one time?
Yeah.
On average, yes, sir.
Average of 6 employees. Were they all in sales positions or installers or?
Most were in sales positions. But like he said, management has a lot to do with keeping people around. So,
and I understand there's a significant turnover in
Yeah.
people, and you may hire somebody and they work for you 2 weeks and you find out they didn't work out, and
Right.
you've got to get somebody to. I understand that, especially when you have a sales-oriented organization. That's an ongoing issue, and we understand that. But so you had, excuse me, approximately 6 salespeople, sales representatives out doing the things that sales representatives do.
right.
But your installers, who was actually installing your systems, and or were your salespeople actually doing the installations?
No, sir. We had an install. I don't quite remember, or I don't know exactly who he is. They deal outside of the office, but I know that they were licensed. They were completely legitimate to be out there. Yeah, they had
Okay.
all their qualifications.
Do you know how many installers you actually had?
Probably two on average.
Had probably, and again, I'm just trying to
sure.
understand. I mean, I'm not trying to be confrontational here. I'm just trying to get a clear understanding. So you had about 6 sales representatives on the average, probably starting in September 14. Were there other managers, say the previous manager, and I don't know his name, and that's not significant, was with the company about a year. So that would have been about a year ago from now. So you had another manager prior to that?
No,
That was the first office manager location.
Yeah, that was our first try at trying to be compliant and making the licensing stuff happen.
Okay, so from the fall of or September 14 to you said you've been here a month, so and the prior manager was here about a year, so that would back up to August of last year. There's about a year gap in there between September 14 and July, August, September of 15.
That's correct. Basically what happens is when we decide to go into a state, and the first thing we go to is the Secretary of State, and we start getting licensed there. Then we start working downhill from there, if you will, to the proper authorities. So when we work on some of this stuff, it will take us a year, sometimes even 2 years. Sometimes the owners of the company will say, okay, we're licensed, we're just going to sit on this now until we feel we have people in place that can sell for us. And in some choices, we turn around and hire a legal contracting company to do the installs for us. So just me personally was well over 90 some odd days, almost 4 months, to get licensed here and sending paperwork.
It's an arduous process sometimes.
Yeah, and we're fine with that, but to explain that these gaps is why sometimes we've been in states for 2 years and done absolutely nothing but just the licensing portion of it. And then sometimes we'll get somebody that shows up by placing an ad that says, I'm the latest and greatest, and we spend 3 months having them train in our office to then turn around and say, well, this isn't going to work, I'm sorry. So yes, you're right, there's a gap there.
Okay, but it sounds like you really weren't doing any particular operations then during that
No, sir.
period? Okay.
No.
So probably your first installations and significant operations, and I'm not going to try and define significant, but probably your first significant operations were maybe a year ago, a little over, give or take, something like that.
Yeah, probably.
Now, I'm just trying to understand and get a clear picture of what's going on here. And right now you've got approximately six sales representatives on hold. And you've got installers that are what?
Well, the licensed representatives are selling. So, but the unlicensed, we're actually sending in their information or getting them licensed.
Okay. Well, technically it's a registration process for employees, but I understand it sometimes, especially if you're not real familiar with it, distinguishing between licensing and registering, and it can be a little confusing. I understand that.
Seeing the importance of it now, it's the first thing we do during the hiring process.
Okay, and I see that and I can understand where you could subcontract out installations to other licensed people, and some of that may have occurred from what you would or indicate. Would that be a correct understanding?
Yes. 96, I've been in the alarm industry for 17 years, and my first job was with ADT. It's part of my job is to sort through what corporate America says we do and do not have to do as policies that a lot of times doesn't match up with state requirements. So when we go to them and say we're going into this state, they say, here's what we need you to do for us, and that's fine, but we need to back up and make sure we're compliant and legal in that state. And so then what we do find out from that point forward is whether or not we can legally hire installer contracting companies to do the work for us. And then sometimes we're even told no from ADT, which is, not really their right to tell us that, because it's legal in the states and that we do this in. But yes. So
well, then I would understand when you operate in multiple states, trying to sort out the different regulations and requirements in a multiplicity of states would be quite challenging, I would think.
it is definitely, yes.
Well, I guess I've digressed, and I didn't mean to. I was just trying to understand the situation. So I guess the point really comes back to Mr. Ezel's registration here. I didn't mean to dominate the situation, dominate the conversation here. Maybe there's some other questions that someone else would like to ask.
Mr. Calcroft?
Could you tell us a little bit about the last couple of charges? I guess you have it. It looks like the most recent was in June of 20. And there was one prior to that, I guess, in 14 and 15.
Yes, sir. The public intoxication is that was a moment of weakness. It was my brother-in-law's bachelor party, and we were basically in public and having too much fun, I guess you would say. And but it wasn't, it was immediately dismissed. It was kind of just like they held me overnight and the people I was with. But Yeah, there was nothing violent involved or anything. It was just acting stupid. And then the previous charge, my parents live kind of in a rural area, so we have kind of trails and stuff by our house. And I was driving my truck back in one of those trails, and the rear end of my truck slipped down and went down into a little hill by the road. And so we left my truck there and then walked back to my parents' house to get it back in the morning because it was late. And then the police basically drove by my truck and saw that it was, got my tags, came back to my place, and then I agreed to come back to the scene of the crime. Well, so they say, but they did a field sobriety test 2 hours later. We had a few drinks at my parents' house, so I mean they failed a field sobriety test, but also that was thrown out as well because you can't basically charge someone with a DUI 2 hours later and it wasn't even on a public roadway. But I'm not trying to defend myself.
Was it on somebody's private property or something?
No, it was
Their private property.
Yeah, it was my neighbor's private property, but he would never charge me for going on there. I go on there, all the time. So
It was okay with them for you to be on there.
Absolutely,
It's just
yeah.
The police saw your truck.
right. Yeah, it was it was interesting, but a lot of money more than anything to get out of that.
Madam Chairman, it would be my observation here, I do not see anything in particular that would bar Mr. Ezel's registration, so I would make a motion that we grant his registration.
We have a motion by Mr. Roberts to grant Mr. Ezel's employee registration application. Do we have a second?
I second.
We have a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations, and thank you for coming to the board.
Thank you guys very much.
Appreciate all of your integrity. We'll make sure that this is all handled properly in the near future, so.
Thank you.
Thank
We
you so
appreciate
much.
your coming all the way from, was it St. Louis?
Yeah.
Kansas City.
Kansas City.
Oh.
Kansas City. here
Appreciate
I
you,
come.
appreciate you coming all the way to do that. There could be some follow-up questions that the board might have, but we appreciate you working with us very much. Thank you.
Thank you very much. Have a good afternoon.
You really do need to keep an eye on some of the stuff. Since you're the qualifying agent, it ultimately comes back to you. Even though, you're not here, it is important kind of for you to keep an eye on some of that stuff in the future.
You're very right. I thought I was doing a good job, and well, now I'm fired up to make sure that I ask more questions and get a lot more nosier. So thank you for that.
Excuse me, were you supposed to be here with Mr. Strand?
Thank you. So Exhibit I is no more?
No, according to the qualifying.
Okay, do you want to go back up to your reports, or?
Let me suggest that the board, some of the answers we got here would indicate there might be some additional investigation warranted into their particular registrations in the past. I would suggest that
Shit.
That the one on Safe Haven, the one that just.
yes,
Yeah,
I would suggest that the number of registered employees that they have and whether they've been properly registered and terminated and so forth, that operation appeared to be just a little bit looser than it probably should have been. So some additional investigation and potential complaints might be warranted there.
All right, we'll take a look at it in the office and see what we have.
And I take it they don't have a physical location in Tennessee. They must be operating from their.
They're operating out of their office in Kansas City. It's
What they're
oh, I
attempting
thought
to
they
do.
had a location here. I guess maybe we should have asked him specifically.
I'm
long as it's not open.
surely he's got some physical presence because he's holding daily sales meetings.
Yeah,
As long as it's not open to the general public, he's in compliance. He just can't he can even have a sign, can he not, that says it's his warehouse or office, but
The only address we have is, North Kansas City, Missouri.
Well, he's not holding daily sales meetings in Kansas City. So I think
That might need to be,
I think there needs to be
addressed
some
with them
further,
too,
some
so.
further investigation there.
All right, we can do that.
okay.
thanks.
And now if we want to move up under administrative matters, that'd be my section, if you're ready. First one is going to be Exhibit B. It's going to be,
You're going to speak into the microphone.
I just wasn't on, excuse me. It'd be Exhibit B. Disciplinary action. Month of June, I suppose. You had the month of June. If you look at the report, it looks a little different from what it used to look like. You should have a total there of $25,000. We look at the month of July, there was 0. As always, it does show all the other programs as well. The next exhibit is going to be Exhibit C, which is going to be the monthly reports, and if I'm not mistaken, you've already received all this information. You have it for the month of June 2016 and for July 2016. Both of these are the same. We still have 2 members that expired 12/31/2015, Karen Jones and Mackenzie Roberts. Both continue to serve until reappointed or another appointment is made. And we would like to thank both of you for your continued serving.
Some days I feel more expired than others.
Now, if you look at the next item, is going to be the budget review, which is Exhibit D. I'm going to give you some totals, but I want you to bear in mind this is not the last budget that you'll be seeing. Hopefully at your next meeting, I will be able to give you your closeout totals for the year. Right now, your expenditures, and I did leave off any cents just to round this off. Your expenditures are $245,320. Add to that your cost backs of $176,847. That makes a total of expenditures $422,167. This total does not include the $5 fee that we charge per licensee. That'll be coming at your final budget. Your revenue is $794,055. Subtract your expenditures of $422,167 and leaves you a total of $371,888. Again, of course, this was without any cents. And there may be some other expenditures coming from the new computer system, so we close out the year. But this board is not in any fear of not being able to end with a positive balance. If you would, we can go to Exhibit E, which is the legislative update. And I'm going to turn to our attorney real quick, because the only update we had was the Right to Earn a Living Act for the legislation.
And the Right to Earn a Living Act is simply all regulatory boards to review their statutes and rules to determine if they're necessary to protect the public. Department of Commerce and Insurance as a unit, the legal division is still looking at that law as well as our regulations and statutes to determine exactly how it's going to apply to us. And once I have more information, I'll be able to provide that to the board.
All right, thank you. That,
We talked about the previous case about Safe Haven, about the street location and could they have a business or just be holding meetings. And I just pulled the website up and handed it to him to let you know what I. He wanted to look at it. He wanted to
Does
talk to
it
him
sh-
about it.
Oh, okay. Oh, okay. All right. That'd be fine. We'll do the same thing when we get back in the office and address that. Thank you. Actually, that's concludes my administrative report. If you'd like, we'll move on down to the alarm employee application review.
Skipped over the experience from
I'm sorry, I did. I could have picked that up, but I did it. Exhibit F, I'm sorry. The application for review here. Ought to be Exhibit F. It's for Barry E. Adams. He wants to be a qualifying agent. I'll give you a few minutes to look that over.
experience with this company.
We actually thought the gentleman was going to be here today, because if you look at what it qualify with is his military experience. You have his DD 214 to review.
I don't know anything about these forms. Number 11, where it says primary specialty, radio and whatever that is, it says 0 years and 0 months.
That's exactly what I read.
No, what's that mean? I mean, did he even have that training? 0 to 0.
That is something we probably have to ask the gentleman.
Hmm.
Normally, when I read a DD 214, there are years and months in that class. Section
Here it
number 11.
says on the next one, military education and
another?
radio.
Yes, he was in the Army, then he went into the reserves. Look, if you you will see on number 13, it does say primary specialist number, title, and date awarded, and it has him down as a radio ComSat repair on 5/10 of 2007. And then it says in number 11, terminal date is 6/15/2013.
Isn't there additional formal education required beyond just level one for a level one burglar alarm in order to be a QA? Just level one
5
is,
years experience,
And-
level one, and the test.
okay,
He's got
Pass
all
both
that.
tests.
okay.
What are all of the jobs listed? Is that tied?
Projects the company has handled.
that-
Yeah, they're just listing the the installations they've done. They're all in Kentucky.
Are they ones he's done?
Well, they have to list 5 installs in each classification applied for per your law.
Is the company licensed to operate in Tennessee? Applicant also. Madam Chairman, I don't see anything here that I would consider barring Mr. Adams' qualifications to be in the burglar alarm and closed circuit television industry, and to register in QA for the state of Tennessee. I'll make a motion that we grant his registration. Actually, it would be a license as a QA.
He's met all the other requirements
Both the exams, yes.
and passed. Okay, I second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to approve Mr. Adams' qualifying agent application. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
We can move down now to the alarm employee application review, which would be Exhibit J, the first one. This individual did disclose a charge, does have the information attached. A written explanation. You do have the court documents. This is for a registered employee application.
I guess I have some question about this. The letter of explanation talks about a belligerent and argumentative 15-year-old daughter. That's just questionable right there, isn't it? Do 15-year-old daughters get belligerent and argumentative?
We didn't used to.
I have no comment.
Madam Chairman, I make a motion that we grant this registration.
Okay, we have a motion by Mr. Roberts to grant this Exhibit J registration. I think it's J, isn't it?
Yes.
Okay. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Motion carries.
We'll move on to Exhibit K. This is also a registered employee, all of them are. You do have a list of the charges there. And did charge on the application. Has a written explanation as well. And you do have the court documents.
I find it interesting that he's sending a letter to us as the Arkansas State Police.
That's what I was just reading.
Do we have commissions that I'm unaware of?
Probably not in Arkansas.
Some of these companies get an explanation and send it to every state. It's
This is an application for a registered employee. Disclosed the significant charges, provided information. Madam Chairman, I make a motion that we grant this registration.
I have one question before we go forward. He says he's gonna be working as an installer in Bentonville, Arkansas?
Idaho.
I thought it,
Yeah, they've moved them from state to state frequently. He applied to be in Tennessee.
okay, I was just confused because I
They
thought,
just use the same paperwork they sent to Arkansas.
okay. All right, we
Got
have
his
a,
application May the 6th. His hire date was May the 4th.
okay. We have a motion by Mr. Roberts to grant this person's employee registration application, would be Exhibit K. Do we have a second?
I'll second.
And a second by Ms. Jones. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. I noticed they have the same file number. Is that correct?
That's an error.
Okay, never mind.
If you look at the cover sheet, the file
no
number on
problem.
this one is file number 35695. Exhibit J was file number 33773. K is 35695. The other two on the agenda are
So we are ready for Exhibit L.
Another registered employee. This individual also listed their charges. You do have a letter. We have the court document, case history report anyway of it. And letters from the individual himself.
Says on his case history, public intoxication, controlled substance excludes alcohol. So according to that charge, he did come out of a bar, but he was under the influence of something other than alcohol. And that was in November 15, I believe. He was charged on the 29th of November of 2015 with it.
The company that he's made application for, I presume, is System Integrators? System Integrations. What are they licensed for? What kind of work do they do? Do we know?
Bedford is the owner of that company.
Oh, okay.
just Per chance. And off the top of my head, I'm gonna say Berg Fire CCTV, and they don't have
You
a
are
central
affiliated
station.
with this company? He is affiliated.
Fire, it's just Berg and CCTV.
Are you familiar with this person at all? You want to come up, or? Okay. So it says in Tennessee, alarm systems contractor's license and alarm license. All it is in Tennessee.
Know who they're talking about?
I do not. I'm not familiar with that.
Yes, you need to be, to introduce yourself, please, for the record.
Jeff Ledford, I'm actually owner of the company, System Integrations.
Say your name again, please.
Jeff Ledford.
Jeff Ledford.
Can I tell him, yeah?
I do not know his history at the moment. First time applicant or a reapply, I'm not sure at the moment. Okay.
He made application and he was denied for material misstatement, did not disclose the charges. And then we got his new application on 5/31 of 16.
Madam Chairman, I'm not impressed with this applicant. Quite frankly, the idea of the shoplifting charges that are we have evidence of here, even though they were 4 years ago, that weighs pretty heavily in my opinion. Property offenses of that type, and then having a registered employee that's going to be installing burglar alarms and facilities and people's homes. I guess I just have a real problem with that. And of course, you've got the public intoxication. That's about 9 months ago. Am I correct in that?
It excludes alcohol.
Okay, let me make just a statement here. I do have the same thing that you have, that the theft by unlawful taking. I believe it was Kmart. But it does say it was for a pretrial release recommendation. I do have the FBI report, and it is not listed on the report.
Okay. There are 2 charges listed here, both in 2012, one in July 13th. Sure, I'm not as experienced in reading these records, but it looks like there are 2 charges here. Now, it may be the same charge.
I believe it's all the same charge, Mr.
Same
Roberts.
charge, single charge
Yeah,
then.
they just say charge for one and charge for
This is just a detailed listing of all of the different court interaction that Mr. Davis had from that arrest.
Well, and it's got one case number at the top, so it should be just
I think it's
one.
just the one case for shoplifting in 2012, and then the public drunk in the end of 2015, November the 3rd.
Actually, what I'm trying to say is, as what the document says for the pretrial release recommendation, there is no.
So it may well be that charge has been, or the record has been expunged.
Even if we don't consider that charge, the other one that was within 9 months, that's public intoxication for a controlled substance, is concerning.
Madam Chairman, I make a motion that we invite Mr. Davis in to appear before the board, and let's get a little bit clearer understanding of what the circumstances are here.
I was going to ask Mr. Ledford, what is your company's policy for drug and alcohol testing?
We're part of Drug-Free Tennessee, so everybody's pre-screened, and then we do random drug tests.
You do random?
Yes.
So your motion is to invite Mr.
Invite Mr. Davis in to give us a little bit of insight into the circumstances surrounding the charges that we have listed here.
Okay, we have a motion by Mr. Roberts to invite Mr. Davis to appear before the board for further explanation. Do we have a second?
Second.
And a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
And of course, we would like his qualifying agent to come in. Thank you.
Get more continuing education.
That's right.
Okay,
All right. I believe we have,
Exhibit M.
yeah, one more. We're just about there. You do have the pages that show where this individual did disclose. Some of it's a little bit hard to read, and then behind that you do have the documents to go with it.
This application is this person a resident of Tennessee? All of the violations appear to be in Minnesota. So he or she, Innocent Star, is that the name here? Innocence Marie Star Bostwick.
That is her name, yes.
Okay. She is a Central Station operator in Minnesota.
I'm not very good at reading some of all of the charges through the way this, and there's not a letter on this one, right? It's just the,
That's, yeah, it's all.
summarize the,
Yes, it's 2003 drugs, 5th degree, pled guilty. It was a misdemeanor. She was sentenced in March of '09. 12/6 of 12 was assault in the 5th degree. They reduced down to disorderly conduct, brawling, and she pled guilty.
know what fifth degree means on either one of those, or is that
That's, each state has unique categories for drugs. I don't know.
If I'm not mistaken, Ms. Hickson, number 1 would be the worst, number 2, number 3.
That was kind of my assumption,
in our state.
that first degree would be worse than fifth degree. Madam Chairman, I make a motion that we grant this registration application.
second?
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, Madam Chair, that does conclude my portion of the agenda.
Hey, do y'all want a short break before we go to the education? How long is your education report? Very short? Well, we'll just continue on then. Okay.
Grateful for. I bet y'all were too. You didn't have this barrage of emails. Here's another course to be reviewed. Please review this course. I did send these out to each of you, all the qualifying agents, and Keith.
I thought you'd sent the whole thing to me.
I sent the same courses out, and I believe I put a note on there that I'm sending these to all of you this time, because I don't have that many. So, who had an opportunity to review the elite CEU courses? There were 4 of them. Fire alarm signaling codes and standards overview for 1 hour. How to sell today's wireless security technology for 1 hour. A course titled 300P1 for 4 hours. And a course titled System Initiating Devices for 2 hours.
Are all of those there are 4 CEUs?
Yes,
None of them for,
that's all that was submitted for this meeting is continuing in.
and it doesn't matter what classification.
No.
Madam Chairman, I carefully read and reviewed all of the information that was submitted on these courses. I'm trying to refresh my memory on the 300P1. And I still haven't found that one.
Save them on the books. I can't get my iPad to move.
I have documentation on all except the one that's labeled 300P1. With the exception of the course entitled 300P1, I reviewed very carefully all of the other courses and felt that they were perfectly satisfactory for the continuing education that was requested.
Including the CenturyNet and Height Vision?
Yes.
All of those?
Yes,
looked at the-
CenturyNet, Hype Vision, and Elite CUs, all except the 300 P1, and I don't have any recollection of that one. So with that exception, I would recommend that the other ones be approved for the continuing education requested.
Have that one, a copy? Are you looking for
I'm
it?
looking, and that could very well be when I cut and pasted from all the Honeywell. That actually sounds more like a Honeywell course. I believe it is just leftover from last month's Honeywell course. It's not on the Elite overview, so
So disregard the
disregard that one.
300 P1.
Well, I would make a motion that we approve the other courses. There's 1, 2, 3, 4, 5, 6, 7, 8 other courses.
CenturyNet, video verification, NetConnect.
That those courses be approved for continuing education in the amount requested for each.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Cockcroft to approve all of the listed courses on the education report, excluding the 300 PI for continuing education with the hours listed. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Who's the education report?
Good. Do we have any unfinished business?
No, ma'am.
Do we have any new business?
No, ma'am.
This meeting is adjourned. Thank you.